All right. Hi, this is Curt Barone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for September 8th of 2025. Brad, go ahead.
So money, 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 money. More money goes out the doors for now we're going to talk about in New Hampshire. We have a city, and this is so important because think people don't really understand what sexual harassment is. So the short part is we have a city who's agreed to settle a sexual harassment suit for 450,000. It's interesting. The insurance company, this isn't the point of this, but it's interesting to me that the insurance company is the one who's going to pay out $450,000. It's one thing to see an insurance company pay 30 or 40,000 for, but everyone should understand, this being somewhat of an exception, insurance companies don't cover losses for intentional conducts. It's against public policy and nobody would do it, right? You can't insure for, oh, if I stole a bunch of money to me, you pay me back my theft. Or if I violate the law by harassing you, normally you don't want to encourage harassment, so the insurance companies don't pay. In some states, like New York and I think California, you can't use public funds to pay for harassment losses. So, which
Wow.
is a new law in New York, and I'm pretty sure California's modeled it. In any event, so here's what we got. So I don't want people to think, oh, harassment, so what? They settled, the insurance company pays it, because that's not typical. That, and especially 450,000 out of the insurance companies to settle this, not typical. But at least in my experience. But what happened is really interesting because here the individual claims that he was subject to, he's heterosexual and he was being picked on, harassed, being called gay, etc. Now, I've used an interesting defense of that, I will tell you. But in any event, so they said it's been going on for 4 years, 5 years. They conduct an internal investigation in
By the way,
2020.
can I interject?
Yeah.
It's been going on for 52 years of my fire service career. This
Oh,
kind of
yeah.
stuff goes on all the time in the firehouses. It's just nonsense,
And,
and 99% of the time it doesn't go anywhere. And then you
right.
have that one that it does.
And look, I mean, he says it's pretty severe, but the kicker is he says they investigated, they confirmed it, right? This is allegations. We don't really know because it was a settlement,
Right.
but they confirmed it, but they failed to stop it.
Right.
That is, that's where the money would start to come in. But I've used this defense. I look, if somebody wants to accuse me of being gay or bi, or I guess you can't say trans, who cares? I don't really care, right? It's not, to me, it's not an insult. It's like saying, oh, you're heterosexual. It's not an insult to me. So I
Well,
sometimes question whether you question somebody's sexuality.
yeah.
So take the opposite. And I guess my question to you is, okay, so assume I'm gay and you're like, oh, you're hetero, you only
Yeah.
sleep with women. Would that be an
Yeah.
insult?
Well, that's not where I went with it, but that's an interesting approach to it. But you attended the leadership case studies class that I did in
Florida.
Florida last couple of weeks ago. All right. And so you kind of have seen my mindset as I approach these types of cases. And the solution is we've got to recognize that some people, most people, 9 out of 10 people, you can tease, you can joke. They're like the equivalent of a burn building. Okay. And this, the metaphor that I use in that class is that most people, you can joke with, you can tease them, you can apply normal peer pressure, bordering on what might be in a different employment or environment, harassment, but it's the firehouse. Okay, 9 out of 10 people, whatever. Just like you said, fine. Call
Don't
me
care.
whatever you want. Call me whatever you want. But we got to recognize that some people are more sensitive, if you want to call it sensitive. But the example I use in the class is they're like the lightweight wood truss building. And 9 out of 10 people are like a fire resistant building that you can tease them, you can joke with them. I have a couple of cakes that firefighters have given each other. We hate you, a cake that says we hate you, another one that says good riddance, asshole, and those types of cakes. Okay, 9 out of 10 people, that's fine. It was sent in love and all that. Okay. But that 1 out of 10. And what I think our training is failing us in is recognizing that 1 out of 10. And they shouldn't be hard to spot. but we've got to, if we're going to avoid these types of cases, our officer corps has got to realize that what could be normal banter in the firehouse to a certain person could indeed lead to a $450,000 settlement. And it's our officer corps that's got to intervene and get the crap to stop.
And courts have
before it
no
gets to
sense of
this.
humor.
No,
right? I
no,
mean,
no, they don't
the
get
fire
it.
services world, nobody understands.
As much as we would like to have a fire service court,
Yep.
right? And we know who the judges would be, okay? But we know that that's not realistic, and that we've got to get better. I mean, we do it for buildings. We recognize when we're dealing with a fire resist the building and when we're dealing with a lightweight wood truss. We get confused sometimes, but usually within a short period of time, we figure it out. But we're not very good at doing that with people.
Right.
And if we're really going to get serious about managing this type of problem, we've got to recognize that.
Yeah. Now, a lot of people would say, just don't make the jokes in the first place, and you don't have to figure out who the people are.
Yeah, yeah. Good luck
but it's not a realistic.
Right. Good luck with that.
Right. Right. Agree.
It's like saying that we're going to treat every building like we're not going in it. You know, and there's people that say that just spray water from the outside. You know, and that's.
But look, I'm not. We are not. If any viewers think we are, we're not justifying or sanctifying or supporting negative comments towards anybody. But let's be fair. Like, so I'm 5'6", right? I mean, my helmet made me like, maybe 5'10", but I always got, I'll send Pinsky because he'll go through the attic, or, who's going to the roof attic? Oh, called out of the chief. Pinsky's going up, right? I mean, I'm always stuck in small places because I'm the guy who could fit. And so, there's always short jokes, small jokes, but I never took them seriously. It's not like they're not trying to hurt me by it. It's just
and that's not to say that the person who takes it personally is at fault for that either. Everybody's different, just like every building is different. Every person is different, and you have to respect where they're at. We expect our officers to recognize, hey, look, Brad's really not doing well with those kind of comments, and we got to knock it off. And then make sure that it actually gets knocked off. Like
which is what killed them here. Right. Yeah. You find that they are making those comments and you already complained to HR saying we don't like it.
Yeah.
That's it. I mean, because now you get into retaliation. We have, the fire service has a very bad way of showing that we are unhappy with what you did by reporting this.
That's a polite way of saying it.
I tried. Okay, let's go to Wisconsin. We had a Wisconsin case last time, I think. Waukesha, right?
We did, yeah.
We don't usually get two Wisconsins in a row, but nonetheless, we have a former Wisconsin deputy EMS chief. He just filed, so these are allegations, a federal lawsuit, and he alleged due process violations and my favorite Family Medical Leave Act violations.
Somebody's been listening.
Yeah, right? Certainly his attorney has. People have no understanding of the power of family medical leave things, but we're going to see it. So here's what we got. He's with Cambridge Community Fire and EMS. It's a fire district. This is in federal court. He's alleging essentially that he was unlawfully terminated from his position as deputy, from his position. And he had a 3-year employment contract. So normally this would just be a breach of contract case, but there is actually a state statute on this, Wisconsin statute 62.13, that gives him additional rights to state that he could only be terminated for cause. Otherwise, you just have a basic breach of contract case. No due process violations significantly, not like federal law. In any event, so he had medical issues, and he then gets replaced under the FMLA. It's got to be temporarily, right? You can temporarily replace someone, but the FMLA requires that you be returned to your position or an equivalent position, but generally your position. And then he files a complaint stating that, I've not been returned and retaliated against.
We get two issues going on here. We've got the deputy chief who was terminated. We have the chief who went on medical leave.
Oh, I see that.
Okay,
Okay,
so
I thought one
so yeah,
substituted for
it's a
the
little
other.
bit. It took me about an hour to really kind of grasp all this stuff. So, but what happened was you had the chief. Now, in the deputy chief's contract, it said that if you're acting for more than, I think it was 30 days, then you will receive chief's pay. Okay. Which is kind of unusual. I know in my career, really, if you were doing it for more than a day, you got
Right.
acting pay. But anyway, that's fine. His contract said if you're in the position for more than 30 days, you get the acting pay.
Yep.
So the chief went off on medical leave. Okay. Now, it's not said in the complaint, but what it seems to suggest is that the fire district did not support the chief, and the deputy chief, now his acting chief, supported the chief. He supported the chief's FMLA
This
claims.
is where the retaliation comes
Right.
from.
And then that's where the retaliation comes in, that the deputy chief did not do what the district board apparently wanted, and which would have been violating the fire chiefs, or I'm not sure if it was fire chief or EMS chief, but the chief's FMLA leave. And so when push can't come to shove, he ended up being terminated. And in reading this whole thing, all I could think of was I wonder that the fire district folks very often are not firefighters. They can be firefighters. In many places they are, but many places they're civilians. And somebody who's used to working in private industry,
Yeah, with a without cause termination.
who could just fire somebody,
Yeah.
that may have been what's going on here. But you would have thought they would have recognized that, and at least once legal counsel and HR got involved, they would have recognized that you can't just unilaterally terminate somebody like this.
Right.
So
Right.
yeah.
So, but they're being smart. This would have stayed in state court if it was just breach of contract. It's I'm curious whether this gets sent back, however, because it's based on a Wisconsin statute. So I'm wondering if they change venue back to state court. It doesn't matter, but it does matter.
Yeah, the FMLA doesn't go away.
No, but the FMLA is almost a tag along claim. And you could sue FMLA in either, I believe, like FLSA, you could do in either state or federal. I don't know.
Yeah. Well, I always say like that removal to federal court is kind of like calling the timeout before the guy's going to kick the game-winning field goal. You're just trying to get in his head a little bit. And you just, the plaintiff filed it in state court. Obviously, they wanted it to go to state court. They could have filed it in federal court, and then it gets removed. So I don't know. Yeah, but I think his FMLA claims are pretty strong. Due process and the state law violation. The due process is premised on the state law violation. So I don't know.
Yeah, we'll see. All right. Now let's actually stay in federal court at least, where we have federal court granting summary judgment, meaning there's no questions of fact that a jury or judge needs to reconcile before we can get a final decision. It's just a question of law. And this is a really most people who are not familiar with these discrimination claims would say, "Oh no, that's a question of fact." And yet, we want people to understand is what is a question of law. Actually, when you stand on good ground. So here, the trial court dismissed the lawsuit. The lawsuit was brought by a former fire captain. This is in Topeka. He alleged race and disability discrimination when he was not promoted to division chief. Now, I'll summarize. The facts are very easy, but we want to talk about the McDonnell-Douglas test, which everyone should know, but we haven't talked about it for a while. So, let's do it again. So here's what happened. They give a list for this position. There's 7 people take the test. There are 4 on the list. Or on the four positions.
The
4 openings, right? But 7 people take it. The person who sued got number 7, the lowest score, right? So he claims I was denied the position based from, and he says a lot of things, based on discriminatory history of the department. They've had other claims. They're racist, whatever. They're biased. And the court comes out and says, listen, we're going to do McDonnell-Douglas. And basically, this is a ping pong test where the first part's easy, right? They have to basically claim I'm in a protected class, I hold a protected position, etc. And that's very easy to do. But ultimately, at the end of this test, we have the ability for the city to show, or the employer, right, generally to show that, listen, yes, we agree this person is a protected class, black, whatever. We agree that they suffered an adverse employment condition. They did not get promoted, right? That's easy. The issue is always does the city or employer have an adequate justification for why they took their actions that have nothing to do with the individual's race or other protected class? And here, what swayed the court, which is very important for people to understand, is that, listen, there were 4 openings, 7 people on the list. You scored lowest, and you took, this is a big thing, the top 4. You exercised effectively no judgment in who you took, right? You took the top 4. Now, one thing that'd be better, I don't think they would do it, would have been if they announced in advance, we don't care who scores what, we're taking the top 4. They didn't. Obviously, the facts worked out to the city's benefit where they knew, hey, we're happy with the top 4, and this guy wasn't in it. If this guy was like number 4, and they chose number 5 and skipped over of them, this case would not have gone away at this stage, right? Absolutely. So the facts here matter, and I think that's what's interesting about this case.
Yeah, and there's one comment here, and I don't know if you can kind of get your memory going back to law school, or maybe you've dealt with it, but it's the whole cat's paw idea. Do you recall that whole concept? No. I remember it from law school a little bit. I remember my dad talking about it. The cat's paw is think of like a fake cat's paw on like a small stick, and somebody moving something, and then they're saying it was the cat that did it. It's like the fake cat's paw moving something. And what his allegation is that the chief and the city discriminated against him by the way they set up the testing process. It's like a cat's paw kind of, and the court basically rejected that, said, that's not. But I thought that whole cat's paw idea, every time I see it, it comes up from time to time in different cases, and I say, oh wow, I remember one of my professors talking about that.
But there's some important language here. We've seen other cases, and as a result of another case, I put it into one of my cases, and it comes here is just because you have a feeling, just because you have some vague belief, right, that there's just something discriminatory go on, your belief, your subjective individual belief is not enough. And the court makes a point to say he didn't bring in statistics to show us, okay, well, all 4 were white, and we've never had a black captain ever, or there's 1 out of 100. They're not doing that. And he couldn't do that, or because the facts weren't that way. So, this is so fact specific, but the judge makes clear he came forward with nothing other than his belief, and your subjective belief without any facts is not enough at this stage. So, kudos to the lawyers and to the facts that just happen to be, right? But to get rid of a discrimination case at this stage, early stage, is very impressive. Good lawyering.
Yep.
So, okay.
And it was upheld.
Yeah, well, right. Exactly. And, the trial court judge and the appellate court says it, put the appellate court in a little tough situation on certain things they didn't consider. And the court's like, well, we can't go back and retry this. This is not a totally new. So anyway, they're bound by some of the things the trial court says. I wonder if trial courts do that, saying, well, I'm going to not discuss something, but I don't know. We're going to see the opposite coming now. So, or soon. So now we're back. I'm so sick of this. We're back to a COVID case, right? And
it's nice to be able to actually use the word COVID without getting a strike against us by YouTube. So
true, very true. And there's an important, I think, statement in this case we're going to talk about. But here's basically what it is. We have the U.S. Court of Appeals, again, an appellate court for the Ninth Circuit. And they are once again upholding a lower court, trial court ruling in favor of Snohomish. Isn't that where I think John Murphy is? Snohomish
He's up there. He's up there. I've done some teaching up there. It's beautiful, beautiful area.
That's what I heard. Okay. In any event, so there was a 2022 lawsuit. 8 firefighters, they were discharged. They challenged the department's denial of their request for a religious exemption from the COVID vaccine. There's nothing new on that. But and we've seen a million of these cases, but what I like in this language and the court says, listen, it was an undue hardship. That's the whole question. Is it an undue hardship on the municipality to not grant the exception? And they go through, they said it is an undue hardship. But one of the very interesting things that the courts do later on now, which they weren't doing in 21, 22, 23 maybe, is they're able to look back and say, listen, yes, we know more now, but we're only evaluating this from what we knew then. And I think that's important, right? It's important to say, so if the vaccines today were proven to cause harm, or they weren't proven to be effective, or wear one mask, wear no mask, wear 3 masks, where, right? It was a changing landscape every day you turned on the news. The court's saying, we just didn't know. And there was a serious health issue at the time. And so we're not going to evaluate in hindsight. And I thought that was a big deal. But they, again, uphold the decision that the city did not have to accommodate their exemption from the vaccines.
Yeah.
But, and so anyone thinking somebody came out with a study today that says the vaccines are harmful, that's not going to matter. You have to evaluate it in the past.
Yeah.
Okay, so I love this one. This one I'm not sure I agree with. Let's debate it maybe a little, but
Yeah, it's worth it. Yeah.
Yeah, we're in Alabama, and we have a court, again, an appellate level court, affirmed that that the town has immunity. So I want to go through these facts slowly. Sometimes I summarize, but these I want to go through it slowly. So we're back in 17. And we have this guy, Bonner. He was driving on a county road, and it's a female, and her vehicle left the roadway and was submerged in a creek. Okay, so then we have Bonner is rescued, the female, by passing motorists, and a bystander who happens to be a volunteer firefighter with McCord Crossroads Volunteer Fire Department starts performing CPR. Okay, so now we have firefighter 1 doing CPR. At some point, another we have the EMS, right, is notified. They're coming. The paramedics are dispatched. But then we have this guy, Geis. I don't know how to pronounce it, but Geis, who's nearby, doesn't belong to this fire department. He's on a personal errand. He hears the call about the accident, so he self-dispatches. He self-responds. I don't have a huge issue with that. He's there if he can help, right? So even though the scene was not his, right? And this is the part I really disagree with the court on. I thought we were going a very different way. But as I'm reading the facts, even though the service was not in Geis's area, and that's again the guy who responded while in the area, not dispatch.
But he was a member of that Cherokee County EMS, so he was dispatched. His unit was dispatched. His department was dispatched.
Right. Okay. So, but he had not been dispatched to the scene. He goes, right? And then here's the part. So the bystander's doing CPR. They asked Geis to take over. Geis, I don't get this, says, end all resuscitation efforts, stop it, and then states over the radio that a death had occurred at the scene. Now, at this point, there's no AED, there's no defibrillator, right? There's no monitor. A little strange.
Well, he's a paramedic, and I'm assuming the other member is just a firefighter.
I got to guess.
So there's a question right there. Medic tells you to stop.
What do you do? And if you don't know any better, if a medic told a basic to stop, but the basic knows the procedure, you might be like, aren't you going to confirm vitals? I mean, but it gets worse because the body's warm to the touch and may have felt cold from the water, but probably not at that point. It sounds like they got him right out. In any event, 5 minutes after the bystander stops performing CPR, the Cherokee County EMS paramedics arrive at the scene. They examine him and find that she's warm to the touch, had a pulse, and had responsive pupils. So that's where I'm like, okay, this is not going the way I saw it. But in the end, right? So I mean, maybe you could, I got to sneeze here. Maybe you could describe the holding here. Because this is getting a little strange. So Well, let me keep going from the decision here. So they sued everyone you would imagine, right? Geis, the CBVFD, the fire department, the town of Cedar Bluff, the Cherokee County Association of Volunteer Fire Departments, okay, and alleging a wrongful death. I don't think wrongful death was right, by the way. Negligence one thing, but it's, oh, well, she had a pulse, so it would be wrongful death if she still had a pulse.
Well, it contributed to her death. She died a couple of days later.
But she had a pulse when they got there, so it would be wrongful death, right? That makes sense to me. Pulse on scene.
Yeah. Oh, yeah. It does. I'm sorry. I thought you said it doesn't make sense. It does.
No, it does make sense.
Yeah, it does
Absolutely
make
makes
sense. Yeah.
There's a pulse on scene. It makes sense to me. So in any event, there was a $100,000 consent judgment against Geis for his negligence. Right. But the express condition of that consent, meaning agreed to settle, that Geis's conduct, they agreed, was not wanton, meaning reckless, right? Yet there's Alabama's Volunteer Fire Service Act that provides immunity protections for volunteers. Now, everybody knows most, I can't say all because I don't know, maybe you do, most statutes say, okay, you're not guilty of negligence, but if you're reckless or grossly negligent, or the phrase a lot used, willful and wanton conduct, right, then there's no immunity. So here, the key issue on the appeal was whether the town, right, through its volunteer fire department, could be vicariously liable, I'll explain that to everybody, for Geis's negligence. Vicarious liability means the employee screws up, but the employee doesn't have the money to pay this, so the employer is liable for the employee's negligence. We call that employer-employee liability. We call it respondeat superior. We call it vicarious liability. Pick your term.
I was thinking we almost need a diagram to diagram this out, because you have the fire departments, for various reasons, are immune. So they're sort of off the hook. You got Geis that he's got immunity, but it's got to be negligence, because if it's more than negligence, he's not going to have the immunity. But if he's got immunity, why are we consenting to judgment? Right. So it's almost like to diagram all this out. He's consenting to judgment because he thinks, or the plaintiff thinks, that that's going to tag liability onto one of the parties who already has immunity.
And the condition, right, saying that it's not wanton conduct with the express condition that it was not wanton. I think that might have been a brilliant move, a pull one over on you move, right, by the insurance company saying, listen, 100,000 is great because we're looking at multi-million. Give them 100,000. We're buying the condition that is not wanton, which would probably be what removes immunity. So here we have the court then talks about the VSA, right, the Volunteer Service Act. And they say that it provides immunity to volunteers who act in good faith within the scope of their duties for a government entity, which the court says he was working for a government entity, unless their conduct is willful or wanton, right? The normal statute. The court then reaffirms a prior holding from another case that municipalities are, of course, are vicariously immune, right? I'll explain this when they're volunteer.
I've never heard that term, by the way, vicariously.
I know, I've never heard vicariously.
I've never heard of that, so I thought it was pretty interesting.
But it makes sense. If the employee is not liable for their negligence because they're immune, then how can the municipality be, other than for like a negligent training or negligent supervision? But that's not this.
Right, but you have a consent judgment. So it's like paradoxical. You just keep going around and around. I got immunity, but I consented to judgment, but I got immunity.
Exactly. I consented that I was negligent, but I didn't agree. We expressly provided it wasn't willful or wanton. So the court rejects the argument that the town waived an immunity defense, which I don't know, I don't get that. But in any event, and then finds that the town had asserted immunity both generally and specifically before judgment. That sounds correct. The court also rejects the argument that Geis, right, the guy who said stop CPR, that his actions create a factual dispute over immunity. Because normally the factual dispute they're talking about is whether his conduct was above or below the standard of care. But here they took that off the table because they agreed it's not wanton conduct. I think they were nuts for whoever did that. To me, that's almost my opinion. It's almost malpractice having agreed to that. Nonetheless, they said even if Geis's conduct could be considered wanton, which clearly it was, let's be fair, the court goes on to say that municipalities cannot be liable for wanton conduct of volunteer firefighter under Alabama law. That's where I'm confused.
Yeah.
let me explain why I'm confused, and maybe you can help me out of my confusion. If there's vicarious liability, right?
Mhm.
So clearly the firefighter can be negligent, and then the employer would be negligent. But now they create this concept of vicarious immunity. If the firefighter is immune, the municipality is immune. But what am I missing under this act? If the firefighter had wanton conduct, right, reckless, etc., why isn't then the municipality immune or liable for that? There's no immunity.
There's their immunity. The firefighter's immunity does not extend to reckless, wanton conduct. The statutory or the immunity, the sovereign immunity that the community enjoys, does extend to willful and wanton conduct.
Which
Okay.
is strange to me.
I think they were trying to thread a needle here, and the court said, it doesn't make sense that you can't, if somebody has immunity for something. This is what they're trying to say. The Geis had immunity for negligence.
Right.
We're agreeing that it was just negligence, but we're consenting to judgment for $100,000.
Taking wanton conduct off the table.
Taking wanton conduct off the table, but the community, the deep pocket, has immunity for both negligence and for intentional conduct. So
that's
they're
one good statute.
And they're saying basically that you can't use this method to tag liability onto the community. Another way to think about it, is the taxpayer should not have to pay for this. That this was a mistake. And I don't think nobody's saying there wasn't a mistake. It was, clearly a mistake, an error. Maybe it was excusable, maybe it wasn't. You have to get into the facts to really determine all that. But bottom line is, you can't make the taxpayers, you can't put the taxpayers on the hook for this. And I think if the parties really intended to give the victim's family $100,000, they should have done it in a settlement, not a consent judgment.
Right.
They should have just settled it and just say, here you go, here's the money. Nobody admits liability. Goodbye.
Yep. And we have a saying, there's only one type of settlement, a global settlement. I'm shocked they did it piecemeal, but I don't know. I'm shocked at Alabama's law. If Alabama allows a municipality to be never liable, right? Even if the firefighter is grossly negligent, wanton, reckless, whatever, that's a heck of a statute, heck of a protection.
Yeah, it's kind of counterintuitive there, because the individual loses immunity protection,
right,
but the municipality still retains it. So
and that's the point of vicarious liability, because the employee never has the money the employer has.
Right.
That's what makes no sense about this, but it's the holding.
Well, and again, it's that we go back to it. It's something my dad told me. I'm sure your dad said, that hard cases make bad law, and you're in a situation where it appears, based on what we see, the firefighter or the medic here made an error that contributed to somebody's death, and nobody's going to be held liable. So it offends our sense of justice.
And what I think, just my opinion, happened is he wanted to go into the water to help. So he's like, okay, that person's dead. Because they said after stopping CPR, he goes into the water.
Right. And there's going to be a factual question about what he said. Because, again, we're dealing with, maybe he didn't say stop. He just said, no, I'm going to go do this other thing, but you keep doing what you're doing.
Yeah, that's a good point. We could change the facts, or it may be the facts, right? The bystander may have said, I'm tired, I can't do this, you do it. Yep. And he says, he said, listen, if you can't go on, stop, but I'm doing something else.
Right.
Who knows?
Yeah, we don't know. And so that's the factual part, that when the case is decided on like a summary judgment, you don't get into all of the details there. You have allegations that have to be interpreted in a way that favors the non-moving party. So
and then you would have gotten to a discretionary decision for which he wouldn't have been held liable, saying, listen, this person is arrested but we have another person possibly trapped. So I'm making a discretionary decision, right, to go into the water to help somebody. And I wasn't dispatched in the first place, so I could do whatever the heck I want. It would have got, I don't know, maybe they wouldn't have paid the
There's
$100,000.
so many ways to look at this. They didn't even get into the public duty doctrine part of this. And I'm not sure if Alabama has the public duty doctrine, but, was there even a duty on which negligence could be premised? There might not have been. So
and did he assume a duty? If he didn't start CPR, he probably didn't assume a duty to that patient anyway. That would have been the strongest defense if that's available in Alabama. So that's what we got for this week.
So kind of crazy week again on Fire Law Roundup. So all right, Brad. Well, thank you very much, and folks, we will see you. If you haven't already subscribed, please subscribe. That means a lot to our improving our algorithm. Please click like. That really helps. Please click share. All of those things help. It allows us to keep doing what we've been doing now for 2 years, over 2.5 years.
More than 2 years,
yeah. So, but that it means a lot if you can help us out by doing that. Okay, and that's going to do it for another edition of Fire Law Roundup.